we're going to move on here in the Menimsha tent. So if you take your seats, if you're just joining us right now, welcome to the Martha's Vineyard Book Festival. And you may have heard this before, but I'll tell you again that the book festival is free, as you know, but we welcome any and all donations, and they can be made at the information tent, which is just behind you on the festival grounds. Also, if you're hungry, there is food for sale. It's from the Homeport restaurant, and so it's just also right behind you. And even the potato chips are good. And so I am now going to hand over. I mean, they're back, but that was my lunch. So that's why I'm so grateful that they had them. But I'm going to hand this over to Susan Dickler, who's going to introduce our author, Gillian Thomas. Thank you. Hi there. We're very happy to have Gillian Thomas here. She's written a great book. It's a book about the women and their lawyers, primarily, and their families, who took a very small piece of the Civil Rights Act, which is called Title VII, which included sex almost as a joke, and made it a reality for women in the workplace, particularly. So the law, what we learn here is that, just because there's a law doesn't mean it's going to be followed or in any way implemented, and that it was courageous women, working women, sometimes educated, sometimes not so well educated, who saw a disproportion in their paychecks, in their access to good jobs, in the ways in which they were perceived as applicants for various jobs, and had the courage and the will to challenge those laws and make the United States a much, much more hospitable place for women to work. There's still a lot of work to be done, and that's why Gillian Thomas is a senior staff attorney with the ACLU Women's Rights Project. And that is a program that has done a tremendous amount of work for women in all aspects of their lives, and has a really fine history. She previously litigated sex discrimination cases at the U.S. Equal Employment Opportunity Commission and Legal Momentum, which was formerly now Legal Defense and Education Fund. She writes beautifully. It's really a joy to read this, and a real education. I want to also mention that the book is going to be in next week's New York Times New and Notable column books, so that's great. And was also named one of the 10 books to read for Women's History Month by the New York Times as well. So it is really a great book. She's going to give us a great glimpse into it, and I hope you all will run to the tent and buy it. So thank you.
Thank you, Susan, for that generous introduction. Can folks hear me okay? I never know if these things are projecting. Thank you all so much for being here. The festival has just been a joy to participate in, and not least because so many of you have shared your stories with me, and it's wonderful to see all of you and see your interest in this book. So thank you very much. Just to very quickly pick up on Susan's introduction, because what I would like to do is tell you a few abbreviated versions of some of the stories in the book. But just briefly to pick up on the genesis of the book and why I wrote it and what the title refers to, because of sex. So the 1964 Civil Rights Act, we all know as the culmination of years of literal blood, blood, sweat, and tears on behalf of the civil rights movement to enact a multifaceted law that would address inequality for African Americans in this country. And there were several sections to the law which were referred to as titles, and some dealt with housing, and some dealt with public accommodation, and even some dealt with voting. But Title VII is the section that dealt with the rights of workers to be free from employment discrimination. And on the very last day of floor debate, at the time the Title VII provision only addressed race, national origin, color, and religion. And then on February 8th, 1964, a virulent segregationist from Virginia, Howard Smith, stood up on the floor of the House and said, "I'd like to make an amendment. I'd like to add sex to the list of protected characteristics." This was met with a great deal of laughter and jokes and ridicule. And to this day, Howard Smith, or he's now passed away, but till the end of his life, Howard Smith kept alive various theories about why he had offered the amendment. But I think and one argument is that it was meant to be a poison pill. Meant to be a poison pill, meaning that it would have killed the bill, that even people who were prepared maybe after seeing images of Bull Connor and German Shepherds attacking children in Birmingham might have been willing to vote for a bill providing for African American civil rights, that to provide them for women, I mean, who would go for that, right? So maybe that would kill the bill. So that's one theory about why Smith did what he did. But the truth, as it often is much more complicated. And he was a complicated person, including, although he was a racist, he also was a longtime supporter of the Equal Rights Amendment. And so the National Women's Party, with whom he was very close, Alice Paul et al., came to him and saw the writing on the wall that the Civil Rights Act was going to pass, and came to him and said, "Listen, if this law passes," and this is not the most attractive quality of the National Women's Party, but they tended to be mostly white and not especially progressive on racial issues. And they came to Howard Smith and said, "Listen, if this bill passes, then white women are going to be disadvantaged in employment, and black women are going to be preferenced by virtue of their race. And that's not something that any of us wants." And so that is the more probable, I think, motivation that Smith had. Again, not the most attractive one, but I'll take it. In fact, Martha Griffiths, a very progressive congresswoman from Michigan, very much wanted sex in the bill and saw in Smith and his motivations and the motivations of others like him who were opponents of the bill, saw it as an opportunity to get sex included and to have a more comprehensive bill. So the bill was voted on with the sex amendment intact. It passed. It easily passed the Senate as well. And so then we were left in 1964 with a law outlawing discrimination because of sex, which is what the statutory language says. But what on earth did that mean? Because there had been no real congressional debate except for some of the spirited floor debate that I just mentioned, there were no committee reports that had been marked up. There had been no testimony. There had been testimony the previous year when the Equal Pay Act was enacted about inequities in the workforce, but the Title VII came into existence with a workplace that had very much segregated, a very segregated workplace, jobs held by men, most women were clustered in jobs held by other women, secretary, nurse, teacher, and most men were in jobs held by other men, and that of course paid better and had benefits and so forth. Want ads were separated by gender. Just 16 years before Title VII was enacted, the Supreme Court had upheld a Michigan law that restricted women's ability to be bartenders. They could only work in bars owned by their husbands or fathers. So the world into which Title VII's sex provision was born was was kind of a blank slate in terms of what did equality between the sexes on the job actually look like. So I was brought to this project by my own work as a sex discrimination lawyer, relying on cases, most of which are in this book, that were sort of like, you might call them brand names. You know, someone comes into your office with a complaint about sex discrimination. Oh, well, that's covered by Meritor v. Vinson or Harris v. Forklift. Someone comes in and says, I'm a firefighter and I tried to get into a fire department, but they had a strength test that kept me and most other women out. Oh, well, that's governed by Dothard v. Rawlinson. And it came to me in thinking about the brave clients I saw in front of me every day and these name brands that I was using, that those were real women. You know, Rawlinson was a real person in Dothard v. Rawlinson, and she didn't have the brand names to help her make her case. And so that the kind of grit and chutzpah and courage that it took to be in a world of segregated want ads and to still say, as Kim Rawlinson did, I want to be a prison guard in Alabama, even though I'm 5'3". That kind of moxie and grit, and in the process, creating a whole body of law that gave meaning to what because of sex meant, was an extraordinary achievement. And so I was really interested in learning the stories, because that's really what law is. A lot of it is highfalutin and kind of hard to understand and arcane in many ways, but really it's just people. It's really just stories. Even corporate law, business intrigue, it's all just people making mistakes or trying to get along. And so I wanted to know those stories and tell them. So what I'm going to do so that we hopefully have a little time for questions at the end, we got started a bit late, is that I would like to tell you about 3 of the cases in the book, and there's the stories of the women that I learned. And I would say that the book falls into sort of 3 thematic areas. So those are the 3 illustrative cases I'd like to read. And the thematic areas, by that I mean that there are 3 kind of general aspects of women's identities as women and as workers that have collided frequently, and frankly still collide. But at least we now have an architecture and a framework for assessing those, how to resolve those conflicts when they come up. And the primary one, I think, frankly, and remains the primary one, is pregnancy and motherhood. And the issue of when you have real biological difference, and let's be honest, when you have real differences in who does the majority of caregiving in most families, even today, what does equality look like when you have that kind of difference? How do you treat men and women equally when they are not subject to equal physiological burdens or cultural burdens? Second is the issue of stereotyping, and I mean that quite broadly, not just the larger stereotypes about what jobs women should hold or can hold or are interested in holding, but also even about how they are supposed to look. What is it to be womanly? What is it to look like a woman, act like a woman? These are characteristics that are still held against us, right? You know, lean in and you're unlikable. You know, need I say more, but 2 words, Hillary Clinton. So these issues of stereotypes about what's the right way to be a woman have frequently come up in legal cases and have actually been the basis for some findings of sex discrimination. And then finally, sexual harassment, which is truly was a transformative moment in our culture in 1986 when the Supreme Court acknowledged that being sexually harassed was a form of discrimination against you. I mean, sexual harassment didn't even have a name in 1964, let alone the kind of social disapproval that it now experiences. So that was an extraordinary transformation, although, of course, as shown by recent events, such as at Fox News and many, many other places, it's still very with us. So I'm certainly not saying with this book that any of these problems have been eradicated. This is meant to be a celebration of these anonymous women, or women I hope are no longer anonymous, in part because of this book. It's a celebration of them and their determination and what they achieved, but it is also just a start to the conversation, not an end, for sure. So I'd like to start with the pregnancy and motherhood section. And I'm going to start with the very first chapter in the book, which actually ended up being the very first case that went to the Supreme Court under Title VII at all, not just the sex provision. It's the case of Ida Phillips. If you don't mind, I'd like to do a very brief reading just to set up a bit Ida Phillips' story. And by the way, she had passed away, sadly, by the time I wrote this book. She passed away in the mid-'80s. And so I glean what I know about her from her 3 children with whom I met, well, 3 of her 7 children with whom I met in Florida, and then also her own writings and contemporaneous legal or contemporaneous news accounts. On a hot Florida night in September 1966, Ida Phillips sat down at her kitchen table to write a letter. Her small frame bowed over a tablecloth printed with green and orange flowers. She quickly filled 3 small pages with her tidy cursive. To the President of the United States, she wrote, "As of this date, September 6, 1966 at 7 p.m., I answered an employment ad of Martin Company of Orlando, Florida, in which the company seeks 100 assembly trainees. However, after completing my application, I was told by the receptionist that it could not be honored due to the fact that I have a preschool child." A neighbor had alerted Phillips to the newspaper notice placed by the Martin Marietta Corporation, a missile manufacturer with a sprawling facility 10 miles from downtown Orlando. With a workforce numbering in the thousands, it was one of the largest employers in the city. Entry-level jobs on the assembly line paid up to $125 a week, more than double what Phillips was making as a waitress at the Donut Dinette. Even better, the job came with a pension plan and benefits, including insurance. "You better get down there early," the neighbor advised. "There's going to be a lot of people over there looking for that job." Phillips resolved to be one of them. 32 years old and the mother of 7 children ranging in age from 3 to 16, she was barely scraping by. Every day she counted up the tips that she'd made during her shift and decided what she could afford to buy for that night's supper. The little bit she had left over got tucked away to cover the bills. She certainly couldn't count on the wages her husband, Tom Phillips, got from working as a mechanic. Those he usually drank. So Phillips, a vivacious, dimpled redhead, had driven the 10 miles to the Martin Marietta facility on Kirkman Road to submit an application. When she got to the front of the line, the receptionist asked her if she had any preschool-aged children, and hearing that Phillips had a 3-year-old, the woman declined to let her apply. "I felt like the world had caved in on me," Phillips recalled. "I had my hopes up so much for it." She needed those wages, and her kids needed those benefits. That's when Phillips decided to write President Lyndon Johnson. "My President, may I say that I believe that this is unjust from the policies that you have administered during your term in office," she implored, "as equal opportunities, as equal employment, and constitutional rights." Phillips hadn't grown up paying much attention to politics, but she had recently registered to vote and, in her words, had started reading the papers cover to cover. She may not have known specifically about Title VII or the 1964 Civil Rights Act, but she plainly suspected that Martin Marietta was doing something unlawful. Phillips' daughter, Vera Tharp, remembered that when their neighbor stopped by that night to check how Phillips had made out, he was incredulous. After all, he worked for Martin Marietta and had kids in preschool, and the company had never objected. Less than a week after she'd put her letter in the mail, Phillips got a response from the White House. Her complaint, she was told, had been forwarded to the U.S. Equal Employment Opportunity Commission, the federal agency tasked with enforcing Title VII, for further investigation. The following summer, the EEOC issued a decision in Phillips' favor. In November 1967, having tried unsuccessfully to convince the company to hire Phillips for the job she'd applied for, the EEOC mailed a notice to Phillips. The agency had done all it could, it said, but she had the right to continue the case on her own by filing a lawsuit in federal court. Phillips definitely wanted to press on. She was too angry not to. Now, she needed to find a lawyer. So, thank you. So she went to a couple of lawyers, white lawyers in Jacksonville, who told her, in her words, they didn't think it was worth fooling with. And so she got to thinking, because Phillips was white, and she got to thinking, who would understand about how to bring a case involving civil rights? I bet a black lawyer would know how to do that. So in 1968, Jim Crow, Florida, she sought out a black attorney who was running for judge at the time and approached him, and he said, well, I'm too busy with my campaign, but I have this young whippersnapper who just joined me from the NAACP Legal Defense Fund up in New York, where he was doing an internship, and maybe he would talk to you. And to give you a sense of how little in the public consciousness the sex provision of Title VII was, I met with this attorney, Reese Marshall, who's still practicing, and he said he met with Phillips, and he was very impressed with her, but he wasn't really sure if she had a case because he didn't know whether Title VII even covered this. And then he said after she left his office, he went and pulled down the statute book from the shelf and looked it up and said, well, there it is. I guess it is. The law covers it. So they had the problem in bringing the case was that Martin Marietta had a workforce of 70% women, and so the company said, well, how can we be guilty of sex discrimination if we have 70% women working for us? It's just this subset of women that we're that we're keeping out because they're so unreliable. Those mothers of young children, and the lower court bought this, and the appellate court bought this, but there was one judge on the appellate court who dissented very vigorously. And this judge said, listen, think of the implications of what you're saying. You take a protected characteristic like sex, and then you add on some sort of plus factor, right? So in this case, it's motherhood. But he said, imagine all of the protected categories under Title VII and how you could carve out categories. So, blacks who are left-handed, Jews who don't have a high school degree. And suddenly you're carving out more and more categories so that Title VII really means nothing, or is severely hampered. And so, as this Judge Brown, Harold Brown, said in his dissent, if sex plus stands, the act is dead. And so, possibly because of that vigorous dissent, the case caught the attention of the NAACP Legal Defense Fund in New York. And even though Ida Phillips was white, they were very, very convinced by this argument that if sex plus stands, the act is dead. They could see that all of the hard work in getting Title VII enacted could go right out the window. And more importantly, at the time, the majority of working mothers, were African American. So they were able to see that their key constituency was very directly affected by this ruling. So in the interest of time, I'll move on, but the good news is that Ida Phillips did get her day at the Supreme Court, and the justices, despite in the oral argument reflecting quite a good deal of confusion over what the sex amendment was actually supposed to do, and Chief Justice Warren Burger expressing that no wonder women made up the majority of the workforce at Martin Marietta because it was small work involving digital dexterity, and he voiced in open court, well, that's what makes women such good secretaries, is that they're so dexterous with their fingers. I guess he has a point. The ruling, though, did go in favor of Ida Phillips. The sad sort of coda to the story, as sadly was so often the case in a lot of the cases in the book, is that it turned out that when it came time to they settled her case after the Supreme Court ruling, and it turned out in fashioning a remedy that Martin Marietta had actually laid off a bunch of workers right after the time that Ida Phillips had sought to be hired, and so she actually didn't really have that many damages in actuality. She would have been laid off. So her back pay, her lost wages totaled $15,000, and she used it to A, take the preschool-age child, little Gracie, to Disney World, B, give her oldest daughter, Peggy, a down payment for her first home, and C, bought herself an air conditioner for the first time in her life in Florida. But that case continues to stand for the prospect and is especially used, and I rely on it all the time, used to defend against kinds of discrimination that don't affect all members of a protected group, but just some of them. For instance, it's been very vital in not only helping in cases involving women who are discriminated against because they're mothers, but also, for instance, a woman who is also African American, or a woman who is also over 40 and protected by the age discrimination law. So, younger women are treated fine, but older women treated not so well. White women treated okay, but African American women not treated so well. And the fact that the Supreme Court has acknowledged that not all members of a group need to be disadvantaged for a violation to be found has been truly revolutionary in terms of representing the vast complexity of women's identities that are in the workplace. Turning to the issue of stereotypes, I want to tell you about Ann Hopkins. Ann Hopkins was, in the early 80s, a consultant at Price Waterhouse, the Big Eight consulting firm. She was a self-described Army brat who had lived much of her life in Texas, very straight-talking, not afraid to use salty language, but also excellent at her job. And she'd been a consultant at Price Waterhouse by the early 80s for about 8 years. And she went up for partner. And her department supported her and put her forward for partner. And then she got the word back that she didn't get it. She hadn't been turned down, but she'd been deferred to the next year. And when she met with the head partner at Price Waterhouse to find out why, and by the way, I should have mentioned, she was the only woman out of 88 candidates. She also had the biggest book of business of any of the candidates. She had brought in business from the State Department and other government agencies that totaled millions of dollars for the firm. And when she went to meet with the partner to find out why she'd been turned down, he started reading her some of the evaluations from the partners who had considered her partnership. And they said things like macho, overcompensates for being a woman, uses too much vulgar language for a lady partner, needs a course at charm school. And then she went to her mentor at the firm, a man, and said, what am I supposed to do with this information? This isn't about my skills. This isn't about my relationships with clients. This isn't about anything about my performance. This is just about who I am. What do I do? And he said, meaning to be helpful, why don't you try to walk more femininely, talk more femininely, wear makeup, get your hair styled, and wear jewelry? She did buy a pink suit, you guys. She tried. But it wasn't the suit, it was her. And the next time that partnership decisions were made, she wasn't even put forward this time by her department. So she got a lawyer, and her lawyer had the brilliant foresight, and I was lucky enough to interview him. His partner on the case had passed away, but Doug Huron, still practicing in Washington, D.C., had the foresight to understand that social science and social psychology was starting to have a role in employment law, and using social psychologists as experts to help educate the judge. Not juries. There weren't juries at that time. The law was amended in 1991 to provide for juries in civil rights cases, in Title VII cases. But to help educate judges about how discrimination happens and how it's experienced by the one doing the discriminating, and how the target also experiences it. And so he found a social psychologist, a young woman, Susan Fisk at Carnegie Mellon, a social psychologist, who reviewed all of the materials from the partners and the decision making and reached a conclusion. Yes, this revealed that partners held what are called both prescriptive and proscriptive stereotypes. So a prescriptive stereotype is women should act like this. And of course we know that this is feminine, pretty, makeup, deferential, smiling. Women, and then a proscriptive stereotype is women most definitely should not be using four-letter words, brusque, not smiling, driven, ambitious, etc. And I've met Ann Hopkins, and I can tell you she is a little brusque. It's not, but the fact was that she was a brusque woman. That was the problem. brusque men were a dime a dozen, especially in that world of consulting. So what was really fascinating when I spoke to Susan Fisk was that, and of course it made sense as soon as she explained it, but she did not interview Ann Hopkins. Because whether she liked Ann Hopkins or had the same impression of Ann Hopkins that the partners did was irrelevant. What she was there to do was to opine about how the partners saw her, and she testified to the judge at trial about these discriminatory stereotypes that had kept Ann Hopkins out of partnership. And one of the most moving pieces of feedback that I got, or as one of the aspects of Ann Hopkins' story, she had never been, like a lot of women in this book, had no consciousness of the women's movement. It had just passed her by. She had been working in male-dominated fields, for her whole career, and she just had this idea that her merit was all that mattered, and she kept her head down, and she didn't think about being a woman at Price Waterhouse. She just was one of the group. And when Susan Fisk testified at trial, it was the first time that Ann Hopkins had met her, and in the hallway in the courthouse outside the courtroom, Hopkins went up to Fisk and shook her hand and said, "Thank you. Now I understand what happened to me." And I thought that was an amazing moment and a very sad moment that I see it a lot in my clients too. The moment that they realize, yeah, this isn't about merit anymore. It's about this other thing that I can't control that others are seeing in me. So the good news, at least from my standpoint, is that Ann Hopkins won at trial and at the appeal, and it went to the Supreme Court. And she won there too. And there were a lot of other rulings going on about burdens of proof and things that each side had to show that I won't bore you with. But what was unanimous was this idea that being the wrong kind of woman, denying someone an opportunity because she's the wrong kind of woman, is just as much a violation of the law as denying her an opportunity because she's a woman, full stop. And that has been huge. And if you take one thing away from today in terms of understanding the significance of Title VII, anything you see in the news now about LGBT individuals making advances in the workplace is because of Ann Hopkins. Because what is more stereotypical than a woman who's assigned the gender of girl at birth deciding, I want to look and act and live as a man? What kind of greater violation of a stereotype is there? Or similarly, I'm supposed to be attracted to men, but in fact I'm attracted to women. So that issue actually is on appeal to the Supreme Court, and we will see what happens with that. Very quickly, because I know I'm close to the end of my time, I have to mention sexual harassment. And at the time that sexual harassment was taken up by the court in 1986, which is really quite extraordinary to me, it was the year I graduated from high school, and that it hadn't long before been decided to be illegal is really extraordinary in itself to me. But at that time, courts had just started to understand that sexual harassment could be illegal. For a long time, they rejected these claims as sort of, clumsy courting gone awry, and they didn't want to make a federal case out of it. But the courts had started to understand the kinds of cases that we eventually called quid pro quo, meaning that if you have the fact pattern of male supervisor propositions female employee, female employee says no, male supervisor fires her. Courts were at least starting to understand, okay, that's depriving her of a paycheck, that's discrimination. But this idea that your environment could be discriminatory and could be just by being permeated with sexual animus and abuse could be discrimination, that was a lot harder, and yet no impact on your wallet. That was harder for courts to understand. And so along came Michelle Vinson, who was a 19-year-old African-American woman who grew up in Southeast DC, very underprivileged background, very unsupportive family that she had run away from and did not count on at all for any sort of sustenance of any kind. And she decided to get a professional job, and she went to the bank where she had a savings account. And she asked the manager, Sidney Taylor, would you take me on as a teller? And he did, and he was a mentor in the whole neighborhood. He was an older African-American man who had started out as a janitor at the bank. and risen to the level of manager, so she looked up to him. And he took her under his wing, and for about 6 months, she ignored the fact that he seemed to be touching a lot of the other women in a suggestive way. He was G-rated with her, and he was supportive of her, and she was very happy with that. And then about 6 months in, he took her out to dinner, and he said, "You are going to have sex with me tonight. I made you, and I can break you." And she also said that he threatened her and her family. And so she succumbed. And she continued to succumb for 3 more years. And the issue in the case was she never was fired, she never was demoted, she had no wallet losses. But what she had was damage to her self-esteem, her psychological well-being, and all the rest. And so she eventually got an attorney. She went to see a divorce attorney and broke down in the divorce attorney's office, and the divorce attorney said, there, I know divorce is hard. And she said, "No, you don't understand. It's my job." And she got a lawyer who had experience with employment law. He'd been at the EEOC, and that case went to the district court level where at the trial she was penalized for the clothing she had worn, that her blouses were too short and her pants were too tight. And the court believed that whatever advances had happened, she had welcomed them. And so it went up to the district circuit court where she won 3 dissents: Kenneth Starr, Antonin Scalia, and Robert Bork. And then she went to the Supreme Court, and she won at the Supreme Court. And by analogizing to racial harassment, which by then had been well established as discrimination, having a noose or KKK carved into your desk was understood to be discriminatory. The court concluded, just like with racial harassment, having to run a gauntlet of sexual abuse every day is discriminatory. And then there were subsequent decisions that cleared up that it didn't have to be harassment just as horrible as what Michelle Vincent experienced, which was criminal, not just abusive. That was the very outer limit of what the law prohibited. That also kinds of harassment that were merely verbal, just words, would also be illegal if a reasonable person would find them to be abusive. So I think I've gone. I'm sorry. 2 final end of stories. Ann Hopkins won her case and went back to Price Waterhouse as a partner. That was her remedy. She was the first person ever made a partner as part of a remedy. The judge could not believe it. He said, "Why do you want to go be with these people who have fought to keep you out for 8 years?" But she said, "Because I earned it." And she ended up retiring from the company about 10 years later. She still lives in D.C. And Michelle Vincent, who is the one person who did not speak to me, which I do understand. I think it was too painful an episode to revisit. The last I knew, she settled the case and used the money to go to nursing school. And so she has a nursing degree or nursing license and lives in the D.C. area. So I think, am I out of time? I don't have time for questions. But I'll be back. We don't have time for questions, but I'll be back as part of the 3:30 panel and also signing books. I'm happy to answer your questions. I'm sorry we started a little late.